In 1958, the foundation stone for the new City Hall was laid by Princess Margaret. Just 3 years later, in 1961, the new building was completed and renamed City Hall. It became the seat of the municipal government for Port of Spain. A mural by acclaimed artist Carlisle Chang, entitled Conquer.
Chair.
Senators, as we resume the committee stage of these proceedings, may I confirm that each senator has the proposed amendments circulated on behalf of Senator Mark, Senator Shriki-Soon, Senator Ramkisoon, Senator Mahabir, and the Minister in the Ministry of Finance. 1, 2, 3, 4. Senator Mahabir. Senator Raful, you need?
Thank you. Senator Mahabir's amendments.
Senator Mahabir. Senator Choate?
Yes, please.
Anybody else need? Oh. Just to remind you all that those were circulated at the last sitting on Tuesday. Yeah. Everyone has the amendments, the proposed amendments, so may we proceed. Senator Mark?
I think I forgot Senator Mahabir's own phone.
Sure.
Yes, thank you, Chair. Thanks very much.
Senators, may I remind you that this bill has 19 clauses, And as I indicated, there are 5 sets of amendments. I am therefore seeking your cooperation in following the proceedings as we go along. Okay?
Clauses 1 to 3.
Honourable Senators, the question is that clauses 1 to 3 stand part of the bill.
I know that
Senator Ma?
yeah, Madam Chair, it may have been left out. Deleting the tax appeal board. All right, cool. I'll
Honourable Senators, the question is that clauses 1 to 3 stand part of the bill. Senator Ramdeen.
Madam Chair, I don't have an amendment, but I would like to make an inquiry to the through you to the Minister with respect to two issues that arise with respect to clause 2.
In respect of which clause?
In respect of 2 of the definitions in
Clause 3.
3, sorry. Do I have your permission?
Yes.
Minister, in relation to appeal, I apologize for not participating in the debate, but the new definition of appeal refers to, I'm concentrating on B, the High Court from a decision of the Valuation Tribunal. I see that in the Principal Act from which the amendment seeks to target, there is an express provision that allows a decision of the Valuation Tribunal to go to the High Court, and in your debate you said you also have a right of appeal from the High Court to the Court of Appeal and from the Court of Appeal to the Privy Council. I don't, when I read the definition of appeal and match it back to Section 22, I don't see that there is any express right of appeal to the Court of Appeal from that decision. So, I've looked at Section 38 of the Supreme Court of Judicature Act, and I'm respectfully of the view that if we don't prescribe for that right of appeal in the substantive law, it would not confer a right of appeal from the High Court to the Court of Appeal and thereafter to the Privy Council. And I think that the right place to do it would be in the definition section.
Senator Ramdeen, the AG would have dealt with this particular issue in his submission, and he assured the House that that was not necessary. So I'm just conferring with my team to determine whether they have the same view. Senator Ramdeen, we are of the view on this side that unless the legislation says that the High Court is the final court of appeal, that the rules of the Supreme Court will allow for the appeal to the Court of Appeal and thereafter to the Privy Council. The Attorney General had adopted the identical position in his presentation on Tuesday.
All right. While I understand that to be the position, Minister, I don't want to seem to think that I'm asking you legal questions or raising legal questions, but the way why I don't think that I don't agree with that position, and I would ask you to consider for 2 reasons. One, in the Principal Act that we are seeking to amend, that provides for an appeal statutorily to the Court of Appeal by virtue of Section 22(1). So, if that position were correct, by a matter of simple reasoning, there wouldn't have been a need to provide from an appeal from the board to the Court of Appeal in relation to that matter. But more importantly, the rules of court, which would be the civil proceeding rules, can't confer a substantive right of appeal on an appellant in any form of matter, because the rules of court only prescribe the procedure by which the right of appeal is effected. So, for example, normally in the High Court, you would have a right of appeal, you have 42 days. In this case, you have 30 days. The rules of court would provide the means by which the right is effected, but the rules of court can't provide a substantive right of appeal to an appellant. So we run the risk here, if we don't provide for it, that anyone who is dissatisfied with a decision of the High Court on appeal from the Valuation Tribunal may find themselves in a position where, may find themselves in a position where they don't have a right of appeal to the Court of Appeal, and then the concurrent right of appeal to Judicial Committee.
Senator Ramdeen, we do not agree with your position. However, because we don't currently see a challenge with putting it in, I am prepared tentatively to accept it. And can we come back to finalize it at the end of the discussion, Madam Chair? Yes?
Just 1 second. I see Senator Choate wanted to raise something. Is it on the same issue, Senator Choate?
Yes, but unfortunately, it seems that I got to the microphone after Senator asked for it to be stood down, as it were. So I don't know if I'll still be able to make my contribution now.
Yes. Is it on the same point?
Yes.
Yes.
Yes. I support what Senator Ramdeen is saying, because in his contribution, I had noted at the time that the Honorable Attorney General had referred to the fact that there would be the continuing right of appeal to the appellate jurisdictions, but had not stated the source of the right. So when I had the opportunity, I looked back at the primary legislation and the current legislation and realized that it had actually not been included. So one of the primary rules of drafting, I think, is clarity. So if we are to go for clarity, then it seems to me that perhaps we ought to err on the side of simply putting it in instead of leaving it out and then having disputes about whether the right exists and so on. So that was just my 2 cents on the matter.
Madam Chair, I thank both members for their guidance. And as I said, I don't have a problem in principle. I would just like to ensure that the AG does not have any concerns with us doing that. So if we can defer this.
Sure. Let me just, members, let me just hold on, because there are some other hands. And I just want to make sure, if it is on the same point, then we are going to defer that point. We're still on clause 3, though, so are there any further points to be raised with respect to clause 3? Yes.
Yes. Madam Chair, you would have observed in my amendments circulated the whole question of the Tax Appeal Board is being proposed for retention, and you'll see in clause 3, subsection Roman 5, where they are seeking to delete. So it's another justification for us to pause for cause.
Sure. Any other question? Yes, Senator Hussain.
Thank you very much, Madam President. Through you to the Minister, when I looked at the appeal issue and section 22(2) of the Act, which restricts the appeal on questions of law only, I find this very restrictive in terms of the way in which we appeal, because when the Valuation Tribunal conducts its, or it makes a decision on any matter, it would have had to take into consideration various facts. And if there is a divergence with facts in terms of what is presented in the valuation return form, witnesses who attend, and also persons from the valuation division, then if there's a dispute of fact and you want to appeal on that ground, it seems as though you don't have that right to appeal based on a factual dispute from the Valuation Tribunal.
Chair, through you, 2 responses to that. One, all appeals tend to be on the point of law, And when the case law is clear that if the facts are wrong, then that would be regarded as a point of law. So I don't see that we need to amend to cater for that.
So then why did we include the words on questions of law only?
Because that is the standard approach for appeals.
Senator Ramdeen, you wanted to add something?
Definitely. I want to add something to what Senator Hussain said, but I wanted to just ask the Minister, through you, Madam President, that in considering the suggestion that I made with respect to the addition of the right of appeal to the Court of Appeal in the definition of appeal, if the Minister and the draftsman would look at Section 23 of the Judicial Review Act, more so 23 subsection 2. Minister, that provides what we did when we enacted the Judicial Review Act is that, again, on the same submission, that in the Judicial Review Act, you have the provision that's 23 subsection 2 that says an appeal shall lie from a decision of the Court of Appeal as of right to Judicial Committee or Privy Council. And I think that if we're going to statutorily provide for a right of appeal to the Court of Appeal, then we might as well do as is laid down in the Judicial Review Act and provide for the right of appeal to the Judicial Committee statutorily, for the reason that because if the Minister has explained, and I will get to the point of law, if you are limiting it to a point of law, I don't agree that that is the actual style of drafting a right of appeal, because on a point of law limits the right of appeal significantly. But secondly, when one has to appeal to the Judicial Committee of the Privy Council and you go under Section 109 of the Constitution, there is an inbuilt hindrance to appealing to the Judicial Committee, which is that you must show that there is a genuine disputable issue, and that comes from the Jamaat al-Muslimin versus the Attorney General decision of the Court of Appeal. And therefore, if it is that we are saying that we want to give effect fully to the right of a landowner to challenge a decision of the Land Tribunal to the High Court, to the Court of Appeal, and to the Judicial Committee, then I think the right way for us to statutorily embed that right in the legislation is to provide for it statutorily in the definition. And I don't think that there's anything that we lose by doing that, because, again, when you go under Section 109 and you don't have an appeal as of right under 1A, then you have very, very limited circumstances in which you can exercise that right of appeal to the Judicial Committee. It's not like how you can exercise it, like the Minister said, to the Court of Appeal. There are very limited circumstances in which you can exercise that right. I think I have the Constitution here, so I can just...
I don't think, Senator Ramdeen, I don't think you need to go into it. I think the Minister has heard your contribution, and we are going to defer Clause 3 for further consideration. Mm-hmm. So the question is that Clauses 1 and 2 now stand a part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 1 and 2 now stand a part of the bill. As I indicated before, Clause 3 has been stood down or deferred for consideration.
Madam Chair,
yes.
If there's any other, can I raise now the other issues that we can have with Clause 3?
Which
save and accept these one with the definition for the appeal?
Which is what I had invited, I think, a little while ago. But yes.
I'm sorry.
So before I defer for further consideration Clause 3, I am going to invite senators to indicate any issue that you may have with the rest of Clause 3. Senator Ramdeen.
Madam Chair, through you to the Honourable Minister in the Ministry of Finance. Minister, while I understand the redrafted position with respect to the definition of owner and the mischief that the drafters have sought to do with respect to capturing everyone who is an owner, an occupier, and then you have the long definition of receiver, attorney, and otherwise. The difficulty that I think this definition poses is when you match this definition back to the penalty provision for not filing, which is linked to the definition of owner. what you have is that you will, as I foresee, and perhaps I may be wrong, what you will have is that you can have different persons over the same parcel of land who are caught by the definition. So you could have the freehold title owner, you could have somebody in adverse possession, you could have somebody who is a lessor and has different tenants. But the problem with that proposition, with the definition of owner being so wide, is that the duty to provide the valuation form to put on the rules will apply to more than one person. And when you have a criminal sanction attached to the failure to do so, it will then attach to different people who can be in possession of a parcel of land, in actual possession, or not in actual possession, and still be the fee simple owner. So the definition itself becomes problematic because in the administration of the Act, you might have different valuation forms that are submitted with respect to the same parcel of land.
Senator, we do, through you, Madam Chair, we do recognize that there may be obligations on different people to comply with respect to the same parcel of land, but they can only be required to provide information within their knowledge. And so they will not be willfully in breach of the provisions, which is what triggers the offense, if they cannot provide information because the information is not in their possession.
No, I know that deals with the willful disobedience in terms of the creation of the offense. But if you have one parcel, a one-lot parcel of land, that you have somebody who has a freehold title holder to it, but they are not in actual possession, you have a squatter on the land in adverse possession, then the way the legislation is set up, by virtue of the requirement to submit the form, the person who is the freeholder will have to submit a form with respect to all of the information. And the person who is in adverse possession will be caught by the definition and will have to submit a form with all of the information. And therefore, the administration of the Act would become problematic because how would the rules be compiled with different persons having different interests over the same parcel of land?
Well, the reason why we don't want to limit the ability of the commissioner to secure information from different people is because we can use that information to confirm the information that we receive from different sources and therefore arrive at a more accurate position. So it is, and as I said, the information being supplied by the individual can only reasonably be information within that individual's knowledge.
But just one last inquiry. If you have two forms that are submitted, if I am an occupier and Senator Obika is the freeholder, and he submits the form as a freeholder, and I submit the form as an occupier because we're caught by the provision as being an owner, on the actual rules for the registration of who is the owner, you can't have two people registered on the same rules or on the same parcel of land.
Well, there certainly will not be two registrations of that parcel of land. So we will take the information about who is the owner and who is an occupier, for example, but we will only have one entry of that property on the roll. But we will have, hopefully, all the information required, perhaps from the combination of the information provided by the two forms.
Amendment. So that clause 3 is now deferred for further consideration.
Clause 4.
Honourable Senators, the question is that clause 4 stand part of the bill. There are two proposed amendments to clause 4. There is an amendment proposed and circulated by Senator Mark, and there's an amendment proposed and circulated by Senator Shriki-Soon. Senator Mark, because yours is the shorter of the amendments, let's deal with your amendment first.
Yes, Madam Chair. In light of the confusion generated by this piece of legislation as to the particular method that is going to be employed as the base to value properties or lands in Trinidad and Tobago, we are recommending that we stick to one specific method rather than a combination of methods as we have under the particular section or clause of the legislation before us. And therefore, we are proposing that what has worked well thus far, until there is some comprehensive study conducted by the government on this matter, we would like to propose that we do not go along with capital value, site value, and improvements on site value, because it means to say, Madam Chair, the government would be engaging in an activity in where they would be trying to gain income and more revenue by utilizing different methods, and you as the property owner would not at any material time have any precision and clarity as to the base that is being employed by the Commissioner of Valuation to value your property. And therefore, we are saying that the old method that we use under the Land and Building Taxes Act, which has now been repealed, has been the annual rental value. And that is what we would like to propose, that be used as the base, Madam Chair, until the government is able to do a comprehensive study and make recommendations accordingly.
Senator Shriki, soon this amendment is very similar to the one proposed by you. Do you wish to say anything at this stage?
Yes, Madam Chair. Through you.
Yes.
Thank you, Madam Chair. To the Minister Minister in the Ministry of Finance, I want to endorse Senator Mark's comment on that there's a need or requirement in my mind to be very specific with respect to the annual rental value. I've heard the argument put forth by the Honourable Minister that there will be times that you may not be able to arrive at an annual rental value, and therefore you may need the freedom to use another method. But my reasoning, my suggestion here is based on we must be definitive as to what the method used, and the reason for it, if you'll allow me, Madam Chair, to just quote from the existing Property Tax Act, just to demonstrate the point. If we look at what is deemed the annual taxable value, the annual rental value in the Property Tax Act, it means the annual rental value of land as determined by the Commissioner of Valuations. So if it is done in the Property Tax Act, we're saying that the annual rental value is determined by the Commissioner of Valuations, and then the annual taxable value is based on the annual rental value. Then if you assign a value to a property that is not valued according to the annual rental value, and you use capital value or site value, then you don't have the ability to assign a tax to it, because the property tax is saying it is based on the valuation put forward as annual rental value. So in my mind, I'm seeing some element of disharmony between the two pieces of law, and therefore, how can we assign a capital value, base a taxation on capital value, and the other is referring to it as the annual rental value?
Any other further comment on this particular issue? On the same, yes?
And it is for that reason, but also recognizing that the Commissioner may at times need the freedom to use the other methods for another reason. It is for that reason why I still said, I still proposed in Clause 4 that the methods still remain, but it must be specific as to why. Thank you.
Senator Hussain.
Thank you very much, Madam President. Honourable Minister, while I was doing my research on the areas of the base value for the taxation, I looked at Northern Ireland, and they had switched their system from the annual taxable value, the annual rental value, sorry, to that of the capital value. Now, before they actually did this, they did a study of the percentage of property that were held through freehold and held through leaseholds, because they were saying that if the majority of property is actually leasehold, you go with the annual rental value because it's easier to actually give a figure of what it would be. So I'm just asking whether or not there was any research or study done in Trinidad and Tobago to determine these figures, and also what is the justification for using the rental value as compared to the capital value. Are we keeping the site value, annual rental value, and capital value, because we will change it later on, or are we sticking to the annual rental value at all material times?
Minister.
Thank you, Chair. The annual rental value has been the value that we have used throughout to impose tax on property in Trinidad and Tobago, and that is the value that we continue to consistently use for imposing tax on property. What I had sought to explain earlier was that there are certain circumstances when to arrive at the annual rentable value, we would have to do that through ascertaining the capital value, because there may not be comparable property that would give us a sense of what the annual rental value of this particular item is. It may not be land per se, it may be plant and machinery. And therefore, that is why we need the ability we need the commissioner to be able to be flexible in determining how he arrives at the value for tax purposes. But in every case, the value that he arrives at that will go on the roll will be the annual rental value. We have, as I said, we have consistently used it. In the past, there have been no challenges with respect to the commissioner's ability to arrive at the annual rental value, how he arrives at it. There may be challenges on the amount, but he has used the different approaches to come to a position on what the annual rental value should be. This is not a variation from what we have done for the last decade, for the last century, and I really don't see the reason to introduce a change at this point. And in respect of Senator Hussein's comment, yes, consideration was given in the past of whether there should be a shift from the annual rental value to capital value, and it was found for the purpose of Trinidad and Tobago, and I think it is safe to say the Minister of Agriculture may be able to jump in and assist that because we have natural resources under the ground, the bulk of our property is now granted under leasehold property. This is where we are in terms of land ownership. But as I said, consideration was given to both approaches and determined for the purpose of Trinidad and Tobago that it is better. And what we have found, for example, by looking at the Barbados situation, is that using the capital value may often give rise to a higher tax charge than using the annual rentable value.
Senator Mark?
Yeah. Madam Chair, I don't know if the Honourable Minister had time to study the Jamaican Land Valuation Act. The Jamaicans, it is 1985, and they spent a considerable amount of time really experimenting until they arrived at a particular methodology, which is now applicable throughout Jamaica. They don't have 3 and 4 methodologies or techniques or approaches in assessing or valuing land in Jamaica. And this is the act here. And I think we should take a page out of the Jamaican experience, because we have abolished or repealed the Land and Building Taxes Act, the Valuation of Land Act. All these things have gone through the window. And what I'm saying, Madam Chair, is that we cannot proceed on what I would like to call, Madam Chair, a discretionary and subjective basis, because the Commissioner of Land, the Valuation of Land, the Commissioner of Valuations, rather, is going to be left with too much discretion with these different methodologies that he's going to be employing in order to arrive at valuation. There must be one base that we can use. So all I'm asking is that if we had studied the Jamaican experience, we would have been able to learn something from it and not have 3 methods employed in one piece of legislation.
Senator Shriki, soon you wanted to say one final thing?
Sure, thank you, Madam Chair. Appreciate that. Just with respect to the clause, in the way now, Mike, the suggestion or the amendment that I've tabled considers the multiple valuation methods. In no way the amendment that I proposed deleted the other methods as the Commissioner would require. But in the wording of the law, as in the Act here, in my view, in reading the Act, it gives the Commissioner
the autonomy or flexibility to use whichever method he chooses to come up with a valuation. And I'm saying the reason, and that's why the part A of it is saying, just as you've said, Minister, Honorable Minister, that the annual rental value should be the method, and I'm agreeing with you there, but it needs to be specific. And then in the event that the Commissioner needs the latitude to use the other methods, then employ it, and not give him the latitude, or give him or her the latitude immediately up front, creating a vagueness as to which method was actually used. So my amendment is actually what you would have proposed here, but it's just in the way in which it's presented.
Senator Amin, you wanted to raise something?
Yes, I wanted to ask Madam Chairman, just an extension from what Senator Sri Kisun was saying with regards to what is already provided for and this difference you see here in terms of the rental value and the capital value. And if it would provide a loophole for a person who wants to make a challenge, a person whose property is assessed on capital value based on the discretion of the Commissioner, and then they are charged property tax according to the value determined, but they want to use that as a loophole to challenge what is being charged. Aren't you providing a space there for people to evade paying?
Minister.
An individual does have the right to challenge a value that is ascribed to his property, and I think he should have that right. He has a right to look at how the Commissioner arrived at his valuation. As I said, there is no discrepancy as to the value on which the property tax will be applied. The Property Tax Act is abundantly clear on that. This provision gives the Commissioner the ability to value property for different reasons, and therefore he of necessity requires different approaches. I understand, Senator Sturkey-Soon, that in your submission you attempted to preserve that right to use other methods for other purposes. What I'm saying to you is that there are circumstances, we believe that they will be limited, but there are circumstances in which to arrive at the annual rental value, we have to start with another method. And I think we have been doing that for decades. We need to preserve that right for the Commissioner, or we will tie his hands.
All right, so Senators, I will now put the question to the vote on the amendment as circulated by Senator Mark. So the question is that Clause 4 be amended as circulated by Senator Mark. Those in favor say aye. Aye. Those against say no. No. The amendment proposed by Senator Mark has not been accepted. I will now move on to the same Clause 4, the amendment proposed by Senator Shriki-Soon. But Senator Shriki-Soon, can you limit now what you have to say to the further part of your amendment? Because we have dealt with that. Yeah? Okay.
Thank you, Madam Chair. Madam Chair, the argument for the second part was wrapped up in the first, so given the Minister's explanation, I would still like to support the amendment, but under these cases, I will just withdraw it.
So you're withdrawing? So, Honourable Senators, the question is that Clause 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no.
No. We want a division.
Mrs. Gopi-Skoon?
Yes.
Mrs. Batiste Primus? Mr. Rambarat?
Yes.
Mr. Sinanan?
Yes. Yes.
Mr. Sinanan?
Yes.
Yes. Mr. Hussain?
Yes.
Ms. Alison West?
Yes.
Mr. Robert Lehunt?
Yes.
Dr. Henry?
Yes.
Mr. Singh?
Yes.
Mr. Cummins?
Yes.
Mr. De Freitas?
Yes.
Mr. Duque? Mr. Huggins?
Yes.
Ms. Lewis?
Yes.
Ms. Romano?
Yes.
Mrs. Batiste Primus?
Yes.
Mr. Mark?
No.
Ms. Haynes?
No.
Ms. Amin?
No.
Mr. Saddam Hussein?
No.
Mr. Obika?
No.
Mr. Ramdeen?
No.
Dr. Mahabir?
Abstain.
Mr. Small?
Yes.
Mr. Shrikissoon?
Abstain.
Ms. Ramkissoon?
Abstain.
Ms. Choate?
Yes.
Mr. Crease?
Yes.
Ms. Raful?
Yes.
Mr. Richards?
Yes.
Honorable Senators, the results of the division are as follows. 20 senators voted for, 6 senators voted against, and 3 senators abstained. So the motion is therefore carried, and Clause 4 now stands part of the bill.
Clause 5?
The question is that Clause 5 stand part of the bill. Senator Mark, you have proposed and circulated an amendment.
Yes.
So I will ask you to...
Yes. Thank you, Madam Chair. Madam Chair, you will realize or appreciate that the schedule attached to this bill, Schedule 2, is very invasive. And it provides, of course, we'll deal with that at a later stage of our proceedings. Suffice it to say that it is quite unsatisfactory for a minister, without referring to the Parliament, on the schedule, which is so invasive and is asking for so much private and confidential information from each property owner and occupier of land in this country, without having the Parliament being given the relevant checks and balances to contain that ability of the minister to whimsically, capriciously, and arbitrarily amend this particular schedule. And therefore, consistent with proper accountability and transparency, I am proposing on behalf of the bench, opposition bench, that any changes and or amendments to the schedule be brought to the Parliament for debate. So members of Parliament who would have debated this bill and finally decided whether to approve it or not, once it is approved, it should be subject to an affirmative resolution. It's against that context, Madam Chair, that I am proposing that this be subject to an affirmative resolution.
But Senator Mark, you also, though, had another part, Part A, of your amendment, proposed amendment. Can you briefly tell us?
Yes. And yes, Madam Chair, I am suggesting, unlike my colleagues on the other side, that this is a very punitive imposition of a fee or a charge on the citizenry of this country. I would have wanted to propose $40, as was done in Jamaica, but I think I would be going too far. But having regard to the initial legislation of $500, Madam Chair, I see no justification for $5,000 increase, knowing fully well, Madam Chair, that ordinary people who are going to be subjected to this provision can be caught in this net quite innocently. And therefore, in those circumstances, I am suggesting that we stick to the $500 and not $5,000, Madam Chair.
Senator Mahabir.
Thank you very much, Madam Chair. Madam Chair, the issues for me concern 5A, because we know that valuations in Trinidad and Tobago were supposed to be done by the state every 15 years from 1948. By my calculations, we should have had a valuation in 1963, 78, 93, 08, and one in 2022. The state has been delinquent in discharging this critical function. And given that the next valuation, according to the law, is supposed to be in 2022, I would like to propose, and I'm not convinced with the argument of the government that we need simply to add a zero. I want to know why $5,000, why not $550? Simply adding a zero is not justification to me. And I can very well see citizens indicating that they move from $500 to $5,000 failing to file the form. Willful may be oppressive, and if I am a citizen and I am in that situation, I can see grounds for challenging the government. But, Madam President, I want to put this thing in perspective. When we are talking about a fine, we have to look at offenses. In the Summary Offenses Act, for pelting a stone at somebody and causing them harm, Clause 69, $1,500. Are we saying that it is okay to pelt someone with a stone and harm and injure them, and that is 1/3 the severity of failing to file a form? So we need to look at fines, and we need to ensure that there is equity with respect to the system. Thank you very much.
Senator Amin.
Thank you, Madam President. I too want to agree with Senator Mark with regards to the fine not being increased from $500 to $5,000. I also want to suggest, Madam President, that this is a very punitive approach. However, on the other hand, I think we could use an incentive in a different way and consider putting some sort of reward or discount for paying early. There are countries who use provisions to provide, for instance, a 5% discount if you pay your electricity bill before its due date and so on. So I think that type of approach, rather than only the punitive approach if you don't file. But if you do file and you file on time or before the due date, which is what the government should try to encourage, if you could consider a measure like that.
Okay. Senator Ramdeen.
I'd like to make an inquiry from the Minister and then make a suggestion. Minister, am I correct through you, Madam Chair, that the power that is given to the Minister by virtue of the section, Clause 5B amendment to amend the schedule applies both to Schedule 1 and Schedule 2?
Schedule 2 alone.
Schedule 2 alone? Okay. Well, then my concern is alleviated with respect to one.
Senator Hussain.
Thank you. Thank you very much, Madam Chair. Through you to the Minister, with regards, I just want to support what Senator Mark had to say with regards to the Schedule 2 of the Act, that is the form. Now, from what happened previously with respect to the exercise where the Ministry was asking persons to submit their forms, there were some issues regarding that the forms, they were telling you to submit additional documents. Now, when I looked at the VRF sample here on Schedule 2, it does not allow for the submissions of additional documents. It doesn't request that. But my issue is that I believe that we should have the parliamentary oversight, because the minister can at any time include anything in this form for you to volunteer personal information, which may actually be in breach of your privacy rights, and also may amend the form to actually request certain documents. So that is my concern with regards to removing the parliamentary oversight from Schedule 2 of the Act itself.
Senator Choate.
Thank you, Madam Chairman. Minister, I just wanted to make a suggestion with respect to the fine. Now, I have no problem with the increase in the fine, but it's just that you will have different categories of persons who have willfully failed to file a return. And I was wondering whether the government would be amenable to considering allowing the commissioner to have a discretion. So somebody with means will if he willfully fails to file the return, can pay a higher fine, but somebody with little means may attract a fine which is considerably less. I think that may mitigate what some people perceive as the sort of broad brush harshness, for want of a better word, of the imposition of the $5,000 fine. And secondly, with respect to the information contained in the second schedule, it may be in the legislation, but I don't see it. Is there anything to protect this information from getting into the wrong hands, so that when this information is collected, let's say somebody can't source it and use it for identity theft and so on, because you're giving all your personal information.
Senator, you can continue. You can continue with your...
Yes. So I was just wondering whether there was any consideration given to that, and if it's possible for us to have something to say that this information shall not be disclosed unless it's to the proper authorities or something like that. I don't have the language on the tip of my tongue, but I'm sure that if the idea is taken on board, that the drafters may come up with something that we could use.
No, just 1 second. The Minister has heard quite a number of comments and she needs to respond. Minister.
Thank you, Madam Chair. With respect to the fine is imposed by a magistrate on summary conviction. And therefore, in the normal manner of interpreting these things, it is a maximum fine. And the magistrate, within his or her discretion, can determine how much he or she will impose up to that limit. So I think, Senator Choate, that covers your suggestion, because contrary to what you said, it's not a fine imposed by the commissioner. So in my view, there's no need to put in tiers to cater for that. The magistrate already has that discretion. I had explained in my earlier submission why we thought that we needed to increase the fine for the purpose of putting a deterrent, and we continue to be of the view that this is necessary. And having regard to the explanation I just provided to Senator Choate, that it is a maximum fine at the discretion of the magistrate, I think that provides the owners with sufficient protection in respect of any action that may be seen to be arbitrary that the commissioner might take.
Minister, just 1 sec. Minister, you wanted to say something else?
I wanted to say something. Well, I need to respond to the comment on the affirmative resolution. Yes, Madam Chair. With respect to the power of the minister, it is a form to provide information for the purpose of the valuation of persons' properties. The minister is not able to amend the form to request information other than that. to put in a clause that every time he changes a comma or full stop on the form that he needs to come to Cabinet to get a debate on that, I think is unreasonable. The Parliament, I think is unreasonable. If you compare that with the tax return form that is changed every year by the Board of Inland Revenue, it is no more invasive than that. It has not been taken advantage of by the Board of Inland Revenue because everybody administering the system understands that any amendments made have to be made for the purpose of the administration of the legislation. And we need some flexibility and agility in terms of administering the legislation. So in light of that, I think it is unreasonable to request that every amendment to the form has to be done by affirmative resolution, Madam Chair.
Senator Raffoul.
Thank you. I had a question about the penalty that's up to $5,000. Does it apply per...
Sorry, Madam Chair, I'm not hearing Senator Raffoul.
My question is about the penalty. Does it apply per property or per owner? So, for example, if one person owns 2 properties and they neglect to file, are they eligible for a fine of up to $10,000, or is it per owner, per person?
It would apply per offence.
Okay.
So if an offence is committed in respect of each return, and you would have a different return for each property, then the prosecution can take place in respect of each offence, and the maximum fine can be imposed by the magistrate.
Thank you.
Okay, Senator Haynes.
I just had a comment on the Minister's response to Section 5B. That is an assumption that it would only be small changes to the form. So what we're looking at is protection for major changes to Schedule 2. And while we understand that it may be onerous if it's a comma or full stop, but what protections are we putting in place for citizens for major changes to the form? And I think that should be considered when making law.
Senator Obika.
Thank you, Madam Chair. For the Minister, in response to the Minister's response regarding the comparison with BIR, I think that definitely does not arise because the BIR, the process for selection of the head of BIR is different to what is proposed here, where a minister can appoint. So it's different. So it must be apples with apples. So I don't think the comparison with BIR arises because of the independence of the BIR.
Now, members, we are on clause 5, and several members have put forward their comments on the proposed amendment of Senator Mark. The Minister has responded. If there's something different from what was you earlier commented on, then I will allow it. But at some point, the conversation has to end, and we have to put the clause to a vote. Senator Ramdeen has asked Senator Mark.
To the Minister, through you, Madam Chair. Minister, I think while one can understand that the imposition of the 5,000, it will affect different persons with different incomes in a different way, proportionately. I was wondering, having regard to the explanation that was given to Senator Choate with respect to her suggestion of giving up power to reduce the amount that can be paid. I understand and I agree with your explanation about it being a conviction, but having regard to the fact that these fines, when paid, go into the consolidated fund, I was wondering whether it wouldn't be a form of relief if we consider giving the commissioner the power to remit a fine that is paid in particular circumstances, so that it can act as a form, whereas you can't interfere with the judicial process of the fine being paid, but giving the commissioner himself the power to remit a certain sum in appropriate circumstances may tamper that hardship that someone who has been fined, for example, a pensioner or someone who, in appropriate circumstances, it can temper that hardship that they will suffer as a result of being convicted and having to pay a fine, without interfering with your ability under the statute to convict someone and to impose a fine, which is a matter for the court.
Senator Mark.
I just would like to ask the Honourable Minister through you, if you're not in favour of an affirmative, and we always make legislation for the future and not for tomorrow, how would you respond to a negative resolution? Meaning that when decisions are taken, it will be tabled and we go through the process. If it is egregious, we can bring a motion to have it, annulled. Would you be in favor of a negative resolution? Madam Chair?
Minister.
Madam Chair. With respect to giving the commissioner the power to remit, I personally don't see it necessary, because the commissioner, if he thinks that there is a reasonable basis to grant relief, he could choose not to bring the matter before the court at all, because he is the one who would initiate the prosecution. So the combination of that and the power that the magistrate has to determine whether a fine will be imposed and the size of that fine, I think is sufficient protection. Senator Mark, with respect to the resolution, I would be prepared to go with a negative resolution.
Well, I just wanted to clarify something with your leave, with the Honourable Minister. And thank you so very much. Senator Choate made a very important observation a short while ago. We have admitted that we have about close to 700,000 properties in this country. And you would agree that a lot of sensitive information is being provided. Now, the question here is that to what extent there will be what I consider to be adequate protection of the information that will be made available to the Commissioner of Valuations, and what provision would you want to suggest? Because there is always the possibility that information could be misused for all kinds of purposes. And therefore, how do you guarantee, John Public, that the information that they are supplying to the Commissioner of Valuation would not be misused for any other purposes than for what it was intended? Where do we have in the legislation directing or ensuring that there is protection for the use of that information? Madam Chair, through you to the Honourable Minister.
Minister.
Thank you, Madam Chair. And Senator Choate, I apologize for not remembering that element of your question. There are two provisions. One, I believe, is in the Property Tax Act rather than the Land Valuation Act, which prescribes the persons with whom the Commissioner of Valuation can share information. And there's also the Data Protection Act that protects information provided to the state. So I think the combination of those things would be sufficient to ensure that there's not general sharing of the information collected by the Commissioner of
Madam Chair, I don't want to go prolong, but just with your leave again. Madam Honourable Minister, through the Chair, you would be aware it is only small sections of the Data Protection Act that has been proclaimed in Trinidad and Tobago. All these sensitive sections that protect my rights and your rights and the citizen's right have not been proclaimed. Unless you are given an undertaking to the Parliament that this matter will be done very shortly. We need to have some protection for all this information that will be provided to the Commissioner of Valuation.
I was waiting on you to invite me to respond. Senator Mark, I have personally been impacted in seeking information for the Ministry of Finance in terms of getting information from other state agencies. So the provision, I believe, that protects citizens' information is or has already been proclaimed. I believe it has been. And so I think there is already sufficient protection between that and the provision in the Property Tax Act for the citizens' information.
right, so honorable senators, I am going to put forward the amendment as circulated by Senator Mark. And then, once that is dealt with, I will then propose the amendment as indicated by the minister with respect to the B part of clause 5. Okay? So, honorable senators, the question...
No, Madam Chair. Having regard to the compromise made,
but
rather than you put in it,
yes,
I'm saying I will withdraw mine,
sure,
and you'll just only put the ministers. Yes, and that's it.
Yeah, sure. So thank you very much, Senator Marks. So Senator Marks' proposed amendment to clause 5 is withdrawn.
You see, I'm a very compromising chap.
Subject.
So we are seeing it.
To negative. So, honorable senators, the question is that clause 5 be amended as follows at, honorable senators, this is a very, very difficult procedure, and I really require members to pay attention or not distract me. Okay? So the question is that clause 5 be amended as follows at paragraph B, 5, to insert the words after the word order, subject to negative resolution.
Madam Chair, it should be made by order amend Schedule 2, subject to negative resolution. We'll have to, I think, read the minister made by order amend Schedule 2, subject to negative resolution. So if we just put it by order, we have to return, yeah.
What is the minister?
Amendment, Madam Chair, should read, the minister may by order, comma, subject to negative resolution of Parliament, comma, amend Schedule 2.
Subject to negative resolution of Parliament. So, members, I will read. Yes.
We will come back to paragraph A, right?
Paragraph?
A.
No, you withdrew.
No, I withdrew the affirmative. Remember, you had proposed. No, if I.
Senator Mark.
No.
I'm not. Listen, members, all I want to do here is to get it right.
Well, I too.
But for me to get it right, you all have to concentrate a little bit on what I am saying. Okay? So I was under the impression, Senator Mark, that you had withdrawn all of your proposed clause 5.
No.
You are now saying, hold on, that you want to have 5A.
Yes.
You are proposing that 5A be amended.
Yes.
And that 5B.
As you wanted to have in favor.
If you remember, what I was proposing as a matter of just having it very clean was to deal with your amendment and then, subject to what we decided, to then move on to add the words.
My sincerest apologies.
So let us therefore revert to that position where we are going to deal with clause 5, the amendment as proposed by Senator Mark. Honourable Senators, the question is that clause 5 be amended as circulated by Senator Mark. Those in favour say aye.
Aye.
Those against say no.
No.
The amendment is not accepted. Honourable Senators, the question is that clause 5 be amended as follows. At 5B, by inserting the words at sub 5, the minister may by order insert in the following words, subject to negative resolution of Parliament, comma, amend Schedule 2. Those in favour say aye. Aye. Those against say no. The ayes have it. Clause 5 is amended. The question, therefore, is that Clause 5, as amended, now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 5, as amended, now stands part of the bill.
Clause 6.
The question is that Clause 6 stand part of the bill.
Yes, Madam.
Whilst I have no amendments here, with your leave, I'm trying to get some clarification with your leave.
Sure. Yes.
Is it okay?
Yes.
Okay. Honorable Minister, I would like to ask if you could clarify for us this section here, section 6, clause 6, I should say, 7A1. We go to should take effect, he shall notify the minister. When we talk about notifying the minister, how is this done? Is it going to be done in writing? How does the Commissioner of Valuation notify or would notify the minister? Is it going to be in writing? Because it just didn't notify. So I just want to get clarification on that.
The legislation is silent. What is contemplated is in writing, but I don't have an objection to putting it in writing.
Okay. Then the other area I want
All right, just 1 second,
okay,
Senator Mal, because I think Senator Mahabe, you wanted to raise something?
Yeah, no,
on the same...
on 7, on subclause 7. Through you, Madam Chair, when I read subclause 7, my understanding of it was at variance with what the minister indicated. Because the minister indicated that there would be a minimum value of 18,000, but the reading here is that he shall record that annual rental value as the annual rental value of such land. And by that, when you look at the sentence structure, you have, and I will read, where the owner of the land in Trinidad and Tobago makes a return of land under section 6, and the commissioner is of the opinion on the basis of the return that the land carries an annual rental value of less than 18,000, he shall record that. You see, that annual rental value refers to the $10,000 or $15,000 that was recorded. But according to your statement and according to your intent, you meant that whenever it is less than 18,000, the Commissioner of Valuations will record the value as 18,000. So I will recommend as follows, for clarity. He shall record the annual rental value as 18,000. So after the comma, after $18,000, he shall record the annual rental value as 18,000. Then it would be clear to me that that refers to 18,000 and not to the lesser value as written in the valuation. Thank you.
Any other? Senator Hussain?
Thank you, Madam Chair, for recognizing me. Through you to the Honorable Minister, when we mention owner of land and this $18,000 limit, is it just restricted to domestic use, or does it extend to commercial use?
Does the 18,000 extend only to domestic use, or does it include commercial use?
There's no restriction in the legislation, no qualification in the legislation, so it will apply to all land. And with respect to your recommendation, we accept the recommendation for clarity. Thank you very much. Senator
Just 1 second, so that we will, at 7, it is proposed that you take off the words, he shall record that annual rental value, take off the words as the annual rental value for such land.
I would recommend, Madam Chair, after the $18,000 comma, for clarity, he shall record the annual rental value. Take out at that. He shall record the annual rental value as $18,000. There. That's it, right? Very well.
The impact of that, please.
So it shall read, clause 7 shall read as follows: where the owner of land in Trinidad and Tobago makes a return of land under section 6, and the Commissioner is of the opinion on the basis of that return that the land carries an annual rental value of less than $18,000, he shall record the annual rental value as $18,000. That is what Senator
Yes, yes, Madam Chair, we are happy with that.
And then at 7A, it has been proposed that you add the words "in writing" after minister.
Yes.
Yes?
Yes, we're happy with that too.
So, Honourable Senators, the question is that Clause 7 be amended. Senator Amin?
Yes, the Part A, 7A, where the Commissioner is of the view that 50% of the land has been valued, the valuation shall take effect. I don't know if the Minister could just clarify here. How can you tell when you have reached the 50%, if the lands are to be valued? How do you tell? Do you have a number? And what is that based on?
It's based on the information within the knowledge of the Commissioner of Valuations, which is why he is the one who will notify the Minister when we have got to that point.
Madam President, before I propose a suggestion, what I am asking, because the thing is, yes, the Commissioner would receive the forms and so on from people. Based on what does the Commissioner decide you have reached 50%? Do you have a listing or a record of the total number of parcels of land in Trinidad and Tobago to be valued?
Well, I think that's what the Minister is saying. I think the Minister is saying from the knowledge of the entity in question that is how you will come to that 50%.
Well, I wasn't getting that. I'm getting that the Commissioner will know based on the applications that are sent in, the valuations that are done and sent. So I am asking, what database are you going to use? I don't want to presume. I'm just asking, what database? Do you have a certain database that will say how many parcels of land in Trinidad and Tobago are there to be valued in total?
Minister.
To determine what 51% of that is?
Yeah. Minister.
Madam Chair, between the information that resides in the Ministry of Agriculture and Lands and the information that is currently in the possession of the Commissioner and that he will gather during his valuation exercise, we will determine what the population of land is and what 50% of that is.
Senator Obika.
Thank you, Madam Chair. My main concern with this 50% arises from you have a cabinet decision deciding on the interfering in the process, and then how do you determine which 50%? Is it that it's going to be 50% as a collective, a representative sample of Trinidad and Tobago, or some parts of Trinidad and Tobago will be facing this tax because they would have been captured by the valuation, and the rest will not be facing the tax?
Minister.
I think 50% is...
Yes.
What is the reason for 50%?
All right, members, I am encouraging members to make your comments, but I'm also encouraging you to make it succinctly. And when you hear me call on the Minister, it's because I think the Minister has grasped what you are saying. Okay, Minister.
The Commissioner of Valuations will be undertaking an exercise covering the whole of Trinidad and Tobago simultaneously, so there will not be one area or areas targeted. And it is on that basis that the 50% will be arrived at.
Senator Mark.
Honourable Minister, through the Chair, how do you justify 50 as opposed to 75%? What I'm asking in essence is this: would not we be allowing the Commissioner of Valuation to not perform his duties properly if we are targeting 100%, and we are saying that we have 700,000 properties in our country, should not the Commissioner of Valuation be able, through the mechanisms that we are going to establish, to advise the minister, look, we have completed 100% of our valuation work, and therefore notification is served in writing to that effect. In addition, we, the parliamentarians who are lawmakers, ought to be informed properly that that has been done. Now, the minister is going to issue an order upon notification in writing, right, on this matter. Shouldn't we, Minister, be given some notification as well that that event has been completed and the public can go at some place to look at a valuation, let's say, roll, as the case may be? So that is what I'm saying, whether you would agree that we, the Parliament, given the order here, be subject to a negative, so that at least this Commissioner of Valuation and his people should not be doing the job halfway. They should go to the 100%, complete the job, and then notify the minister, and the thing takes effect. Madam Chair, that is what I'm trying to get clarified.
Minister?
Yes, Madam Chair. The 50% is not the end game. It is the point at which this tax starts to be imposed. The Commissioner of Valuation, after he notifies the minister, will continue to do his job with the intention of completing the entire valuation as soon as possible. So it is not that anybody will get relief from taxes. It is just a start point because we need to get it started. And as I indicated on Tuesday, there is no way that the Commissioner of Valuation can say at any point in time, I have evaluated all the buildings in Trinidad and Tobago, because one could have been completed 2 days after he finished what he thought was 100%. So the 50% is a start point to get us there, and he will continue to do his valuations to complete as expeditiously as possible.
All right, so Senator Amin, I think, is there anything different from what you have raised before?
Yes, it is.
Yes?
I wanted to ask the Minister, the next 50%, those who have not filed, when you do reach to assessing them, are they going to have to pay taxes from the date they are assessed, or are they going to have to pay from retroactively?
The intention, as I said, is to complete all the valuations within a particular period, so we do not expect to span the different years of assessment. So we expect everybody to pay from the year of commencement of the tax.
So, Senator Obika, at this stage, I think I really have to put, okay, I'm just the last comment from Senator Obika on this clause.
Thank you, Madam Chair. Basically, how are persons who are not valued going to be taxed? At what rate?
Well, that... Minister?
Yes. I didn't say that people who are not assessed will be taxed. I'm saying that everybody will be assessed, and will be assessed in the shortest possible time, and thereafter they will be taxed.
So they will pay retroactively from the beginning, whenever they are? They will pay from the same date as those who are assessed in the first 50%.
That is the intention.
Yeah. So it's retroactive. Yeah, it's retroactive. That's it.
I wouldn't say retroactively. I would say same period.
So, Honourable Senators, I'm now going to put Clause 6 to the committee. The question is that Clause 6 be amended as follows. Under 7, well, Clause 6 will be amended as follows. I'm going to read 7. Where the owner of land in Trinidad and Tobago makes a return of land under Section 6, and the Commissioner is of the opinion on the basis of that return that the land carries an annual rental value of less than $18,000, he shall record the annual rental value as $18,000. And 7A1 will read as follows: where the Commissioner is of the view that more than 50% of all land in Trinidad and Tobago has been valued and that the valuations should take effect, he shall notify the Minister in writing. Those in favor say aye. Those against say no. The ayes have it. Close. Yes, yeah. So the question is, therefore, is that clause 6 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. No. The ayes have it. Clause 6 as amended now stands part of the bill. Honourable Senators, this is a good stage for us to suspend the proceedings of the committee, and we will return at 5 p.m. So the committee is suspended until 5 p.m.